Our favorite sex offenders, our predators, are back in the news. We're talking about the two big ones, of course, Harvey Weinstein and Ghislaine Maxwell. They're back in the news because Harvey Weinstein, he's already been sentenced to 23 years in prison, but he's going to go through another trial again. They are extraditing him from New York over to LA, and he's going to stand trial again for a number of other sex crimes. So let's take a look at what's going on here. Then we're going to get to Miss Maxwell. So Weinstein, now he's being sent over. He's a convicted rapist, former movie mogul. He's going to be sent over to California. A New York judge ruled on Tuesday that he's going to be extradited. He was convicted of third-degree rape in February 2020, sentenced to 23 years in prison. So he's currently at the Wendy Correctional Facility in Buffalo. He's been charged with 11 counts sexual assault in LA. So 5 women now accused of assaults in LA, Beverly Hills from 2004 to 2013. Okay, rape, forcible oral copulation, sexual battery by restraint, sexual penetration by force. His attorney said, "We're disappointed in this decision today." Just now, his attorney filed a writ of habeas corpus in the LA County Superior Court, asking the court to hold off on the extradition until he can receive the needed medical care here in New York. So you're going to see this kind of theme here, right? We've seen it with Ghislaine Maxwell. We've seen it with Harvey Weinstein, that they need, additional resources and things like that. So Weinstein now is going to be, on his way back. Let's finish this article. It says the writ says that his rights would be violated by extradition because he's got a degenerative eye condition that requires months of medical attention. We have Elizabeth Fegan and another attorney who is over in LA. She says, this is excellent news, so she's thrilled about it. Says he has used every excuse for a delay. She says, time's up. He's going to have to answer again for his horrific sexual abuse. Gloria Allred, lawyer representing 2 of the women, says she's very glad. I'm looking forward to seeing Weinstein finally appear in LA. One of the many women who have accused Weinstein of sexual assault, Louise Godbold, said in a statement that she is happy that 5 more women will have the chance to face their abuser. Sadly, the statute of limitations means that at least 100 more can only look on. So it's incumbent LA extradite. So he's going to be extradited. It sounds like he's entitled to a trial within 180 days, although it's unclear at this time when he will actually arrive in LA. So we'll see. Now, we talked about something like this. Remember in the Rittenhouse case, Kyle Rittenhouse was charged out of Kenosha, Wisconsin. He went across the border back to his home in Illinois, and they extradited him. And he had some pretty bad lawyers at that time, but they were going to be challenging the extradition, and they failed massively. And if you recall, what happened there is when we talk about extradition, it can be a little bit complicated because you're dealing with 2 different states and they've got their own rules and how they process things. And so you kind of have to be somebody who sinks some time in to understand what the relationship there is. But in Kyle's case, what happened was he went back over there to Illinois. They challenged extradition. The judge granted it, and they said that they were going to challenge the grant of the extradition. So they were going to appeal it. They wanted to keep Kyle in Illinois. And so John Pierce, the attorney there, said that, he went into court, we're going to fight this till the end of the earth. But Kyle was already on the truck going back to Kenosha. Okay, so I think it was like on a Friday. He on Twitter all weekend, we're raging, appeals. And Monday morning, Kyle's in Kenosha in front of a judge. So, that might happen here, right? We're talking about, they're going to appeal this. They're going to contest it and blah, blah, blah. We'll see whether or not that actually happens. And sounds like, yeah, if I had to guess, are we going to have a Harvey Weinstein trial in the next 120 days? No, definitely not. I would guess that would be something that we see far down the road. We'll see, though. All right. Now let's talk about Ghislaine Maxwell, because this is where the good stuff is. Ghislaine Maxwell, now, this is her attorney. We've talked about their attorney a lot here. I want to show you what's going on. So this was filed on 6/15 late last night, 32 pages, looks like. We're not going to read all 32 pages, of course. This is from Bobby C. Sternheim, defense lawyer extraordinaire. I am so sort of impressed by this firm, or this woman or person. I don't know the gender, but here's what they're saying. Dear Judge Nathan, this letter is submitted in response to the government. Third-hand information presents a one-sided review. So let me frame this out a little bit before we start getting into the document. What's been happening here is Bobby Sternheim has been just peppering the government and the court with all sorts of information and requests. And we've talked about this on this channel here previously. Ghislaine Maxwell, the government, has told us that she's got 2.3 million pages of documents that she needs to go through. Okay, when we first came up with that number, I think Ma Fox was on the show, and he did an analysis for us, and he said that if you if you sort of add everything up, like 2.3 million pages, it would stack up to like 900 feet high, which is like one of the taller skyscrapers in America. Okay, it's a lot of documents, a lot of material. And so in order for a defendant to be able to process all of that, they got to go through it, right? Every single document, every single sentence, period, hyphen, everything, so that you can prepare for your defense. And if the government's going to be disclosing 2.3 million pages, well, by God, you better believe that Bobby Sternheim is going to demand every scrape of leeway in order to process that amount of documentation. The judge is going to have to look at that and go, are you serious? 2.3 million pages? You can't like whittle that down a little bit? All right. So then the judge has to be accommodating to Ghislaine Maxwell, because there's basically an unreasonable accommodation that must be met based on what the government is providing. Okay, so based out of this sort of mess that's happening, Ghislaine Maxwell now, her attorneys are just fighting for every inch. We want everything. And every time that the guards do anything that's sort of encroaching on Ghislaine Maxwell's free space, they say that this is a violation of her due process rights. You don't want guards hanging over her while she's going through her formal documents, right? The guards are with the government. So we don't want them to see what she's doing to prepare for her defense. There's a major conflict there. So every time there's been any incident, Bobby Sternheim just fires off a letter and says, hey, the last time we talked about Ghislaine Maxwell, the allegation was that Bobby Sternheim brought something in with her and left it with Ghislaine Maxwell that she shouldn't have done. And then Bobby Sternheim fired that off and said, are you accusing me of committing a crime? How dare you? And now I want everything from you, person who's accusing me of that crime, which I think was the prison facilitator. So now sort of what's happening here is there are all these different procedural techniques and tactics that are being brought into this case. It's not even really about this allegation of sexual assault involving minors from 20 years ago. This is all about now due process problems, due process violations, because the guards are interfering with Maxwell's ability to prepare her own defense, which is a very fundamental philosophy, concept, and right in this country. So now what Bobby's doing is every month or so often, there's a periodical requirement that the government updates the court on the conditions of Ghislaine Maxwell, because if she can't sleep, she can't prepare for her defense. If she can't eat appropriately, if she doesn't have proper facilities, then she can't prepare. So when Ghislaine Maxwell then has a trial and loses her case, guess what? Appeals because of due process violations. Ghislaine Maxwell was not afforded the ability to prepare her defense. Of course she lost, based on the fact that the government didn't comply with standards of care that are appropriate. The penalty, they're going to argue down the line, this is coming 2 years from now, the penalty should be a dismissal of the charges. So we're going to see that. What they're doing right now is they're just laying it all out. They're sort of laying out the framework and they're just walking their way through it. And they're doing a pretty masterful job in one man's humble opinion. Let's take a look now at what's going on. So now this is Bobby Sternheim sending this letter over to the judge saying, hey, we're responding to the government's letter June 7th. We're updating the court about the conditions of Ghislaine's detention. This letter, like the one before, it contains second, third-hand information. It prevents a one-sided review, giving the court, the public a false impression that Miss Maxwell is detained under favorable and privileged conditions. So she's saying the government sent a letter on June 7th, and they're basically saying that she's living in a resort. It's not the case, Bobby says. Each time the defense feels compelled to respond to give the court and public a complete and accurate picture of the unacceptable conditions of her confinement. This is not the purpose that these updates were designed to serve. Okay. Accordingly, the defense requests that any further updates be limited to changed circumstances. Okay. So they don't like what the government is sort of surmising for the court. Counsel for Ms. Maxwell can personally attest to many problems that are not reported to the government, not conveyed to the court, not docketed for public review. The following is a sample of new and recurring problems. Let's see what's going on in here. We've got Ghislaine Maxwell says, last week, raw sewage permeated Ms. Maxwell's isolation cell, necessitating her removal to another cell. So sewage is coming up the toilets. We've got vermin droppings. They fell from air vents, so that's nice. Guards now prevent Ms. Maxwell from removing legal documents from the video conferencing room for review during the lunch hour. So they're not letting her get her legal documents. See, due process problem. Obviously, you can't prepare for your case if you've got sewage coming out. You've got vermin droppings coming from the air vents. On Sunday, guards refused to allow Ms. Maxwell to bring a notebook in to her scheduled in-person legal conference, disbelieving her assertion that it contained legal material. Okay, so she has a notebook. She says, no, these are my legal notes. And they say, no, we're not going to let you have that notebook in. We don't think there's legal material in there. She says, yes, there is. They say, that's too bad. You can't take it. So can she open them up and show them? No, she can't. So she just has to leave that out. Now she's going to say, I couldn't take notes during my very important legal preparation conference room meeting. And this is her attorney making these claims. Okay, so this is a little bit different than some other complaints, let's say from some random prisoner. This is how the guards view it and how the courts view it. Oh, that's just some random person. Who cares, right? Who cares what they say? They're subhuman. They're just criminal scum. So we don't really care about, we're not going to take their complaint seriously. Now you've got a very reputable attorney who's got a lot of power behind her, who is now making these assertions to the court and putting her reputation and her bar license on the line, confirming these things. It has some heft to it. Okay. It contained legal material. A guard reviewed the contents of the notebooks. So the guard actually looked in it, read the pages containing confidential and privileged work product. So that's just outstanding. That's just great. Before permitting Maxwell to bring the notebook into the legal visit. So I was wrong. The guard actually said, oh, it is? Let me see. I'm going to read it. Oh, man. Contrary to previous legal conferences, somebody needs to smack those guards in the head and just tell them, hey, let her have what she wants, because they're going to that's a can opener. I'm a defense attorney. I'm like, oh, that's a beautiful can. Let me get my can opener right there. Just open it up. Ooh, that's going to be delicious. We're going to eat that up and enjoy it. Contrary to previous legal conferences, neither counsel nor Ms. Maxwell were permitted to have any water in the individual conference room during a 4-hour legal conference. Okay? You can't even drink. 3 to 6 guards watched Miss Maxwell and counsel for the entirety of the conference. So 3 to 6 guards, making sure. So now you're watching, now you're making arguments. Are they overhearing things? Are they reading your lips? What are they doing? Why do you need 6 guards watching a private meeting with your attorney? Neither counsel nor Miss Maxwell were permitted to use the most rudimentary of earbuds to listen to audio files on the laptop. So they had to turn the volume to be raised to maximum level. Miss Maxwell, she can't have privileged communications with her counsel and adequately prepare for trial if the prison guards can hear what she is reviewing and discussing with counsel. Hello. Due process problem. Prison guards ordered counsel to reposition her portfolio, which was being used to shield glare from the plexiglass divider, separating counsel to permit her counsel to view a clear view of the laptop, because the portfolio was restricting the guard's view of counsel. Right, so she holds. There's a glare. They're shoving a laptop through a plexiglass or whatever, and she puts up. Sounds like a portfolio to block some of the lights. And no, you can't do that. So they want to see apparently what she can see. Oof. The prison guards then ordered counsel to reposition her portfolio, which was being used to shield glare. Already got that one. At one point, a prison guard interrogated counsel about what she was doing with her hands. Counsel was blotting a bleeding finger with note paper. So that's it. At the conclusion of Sunday's legal visit, counsel requested the guards inventory Ms. Maxwell's documents in the presence of counsel to avoid the problem that ensued the last time when counsel was falsely accused of improperly leaving documents with Ms. Maxwell. Yesterday, the monitor, which had been used for video conferencing for months, was repositioned to a distance further away from Maxwell, impacting her ability to review the screen-shared documents with counsel. The request to fix that was denied. Today's video conferencing was reduced by 90 minutes, while changes were made to the equipment, so she's not getting the time. So, they come to these different agreements, right? What her attorney is negotiating with the courts is time. Okay, Bobby, how much time does Maxwell need? 24 hours a day. Well, we can't give you 24 hours a day, so how much? Well, at least 16. Well, we can't give you 16 either, so how about 12? Okay, we'll take 12. So she gets the 12, and they reduce it by 90 minutes. So then they go, you violated your own standards that you just set, Judge. It's due process violation. Now, which had these changes have disrupted the video conferencing. This had been working well. It's now severely impacting the attorney-client communication. Oh no, and it's severely impacting the ability to prepare the case for trial. On counsel's end, the audio is impacted by a whirling, whistling sound like water going down a drain. The video is completely blurred, causing eye strain, compromising the shared documents, which are too hazy to decipher. On the prison's end, the audio is loud and echoes, or on the sort of the other side of the plexiglass. The audio is loud, it echoes, it makes it difficult to understand. The monitor is enclosed with a box and a plastic cover. It's now positioned 3 to 4 feet away from Ms. Maxwell. This distance impacts her ability to view. She has to contort her body. Her back and neck are injured, risk further injury. Just all she wants to do, everybody, is just see those legal documents, man. She just wants to prepare her own defense. Poor Bobby Sternheim is just noting how impossible it is to do that. So we'll wrap this up. From Bobby Sternheim says, during a recent sentencing in which defense counsel described deplorable conditions, Judge McMahon acknowledged that the defendant had been subjected to conditions as disgusting and inhumane as anything I've ever heard about at any Colombian prison, but more so because we're supposed to be better than that. Okay, from a different case. Now we have Judge McMahon boldly stated there is no excuse for the condition in these two institutions. Detainees should not suffer for the incompetence of the U.S. Department of Justice and its subsidiary agency, the Bureau of Prisons. I will do what I can to bring your situation to people who will who, if they give a damn, might do something. Okay, from a judge. A judge is acknowledging that. What a joke the Department of Justice is, right? Exhibit A. Bobby Sternheim is calling that out. Numerous complaints have been brought to everybody's attention. Little, if anything, has been done to improve Ms. Maxwell's conditions. The government updates the court to embolden the MDC to maintain the status quo. The ever-changing rules are negatively impacting her ability to prepare for trial. They're interfering with her privileged attorney-client communication. The hyper-surveillance of Maxwell and counsel during legal visits is highly inappropriate and invasive at minimum. This should not be sanctioned by the court. Very truly yours, Bobby Sternheim. So, got that one fired out. Now, a lot of issues in there, right? Most things you might say to yourself, well, is that big of a deal? And individually, maybe not, right? Individually, if you have a sewer leak one particular day, you fix the toilet and it's resolved. But that's kind of not what's happening here, right? With Maxwell, it has been something that has been a repeat problem. And they're doing that sort of on purpose. Bobby Sternheim is just making a record. It's death by 1,000 cuts. Due process, due process, due process, due process. And then what they do is they just bundle those all up and they say the same thing that the police say on a regular basis. The totality of the circumstances. Any one of those individually is not enough. But when you add them all together and you consider the totality of it in context, it's a due process violation, isn't it? Let me run through briefly what letter they were talking about. So this is what the government was saying. Firstly, probably should have started here, but we'll just run through this quickly. The government submits this letter to provide an update regarding the conditions. This was posted. So this was sent, it looks like, on June 7th, but then it was filed today. So the first time I saw it was on June 16th, but it sounds like this is what came out to Bobby Sternheim previously. So they're saying that that the defendant, she receives more time to review discovery than any other inmate. They say that she's permitted to review 13 hours per day, 7 days a week. During that time, she's got access to a computer. We already read this, actually. We've already covered this one, I think, the last time this came out. So I'm not going to do it again here, but it is, let's do a conclusion here, and then we'll see if there's any questions ready to go. But after any in-person visit the defendant receives, they conduct a body scan of the defendant, non-invasive machine scan. They check for any secret contraband. The defendant's cell is checked once per day for contraband. Finally, as discussed in the government's report, the staff conducts wellness checks every 15 minutes at night to confirm that she is breathing. She continues to be in view at all times, necessary for the safety of the institution and the defendant, including the other details. MD staff and psychology staff continue to monitor her daily. Then we have a redacted sentence, so it must be something about her medical condition. Staff continue to assess that she's physically healthy. Should the court have any questions, let us know. So, all right, so let's take a look at some questions over from our community at watchingthewatchers.locals.com, which is really the place to be. It's kind of the best place on the internet, and I want to invite you to go check that out. First up in the house is from Jeremy Metrita, says, I'm not sure which is worse, solitary confinement or never having privacy. Oh, good question. Yeah, probably never having privacy would be worst. Would be worse. I think I could do solitary. I don't want to do solitary confinement. Okay, Kamala Harris, relax out there. But it's, never having somebody just look at everything. It's so just degrading. Watching you go to the bathroom, watching you eat, watching you wipe and everything. Ugh, humiliating, right? But we want to make sure she doesn't kill herself or be killed like Epstein was, however you want to interpret that little debacle. Now, let's take a look at our last question of the day from Dog Whistle. Says, How do we know the government wants to know what she is saying versus, say, Clinton and Epstein's friends? She can eat out. Rat out. Okay. How do we know the government wants to know what she is saying versus, say, Clinton and Epstein's friends? She can rat out. So, you know, it's a great question. It's kind of a complicated answer, but there are, you know, in criminal cases, there are possibilities for plea deals. Okay, right now, Ghislaine Maxwell sounds like she's not even remotely considering a plea deal, right? Or maybe the government is not even offering her one. But in most criminal cases, that's what happens. The defendant is charged with a crime. The government says, all right, look, we think that we can convict you on these three, but we're going to drop off the most serious charge if you agree to plead guilty to the lower charges. We think we can get you on the most serious one, but we're not positive. And because you've made some good points, we're going to let you sort of plead guilty to a lower charge. Now, there are some situations where that's worth it. If there is a significant benefit, right? I always tell people that you shouldn't be taking a plea deal if you could get the same thing if you went to trial and lost. What's the point of just sort of rolling over and pleading guilty rather than asking the court to find you guilty or asking the jury to find you guilty and exercising your presumption of innocence all the way up until the last moment? Some people, though, there are situations where you say, well, you know, the risks, the reward, the cost benefit analysis don't really make sense. And so we're going to just take a plea deal because we have achieved some major benefit, right? Let's say, you know, if we go to trial, we might be looking at 5 years in prison. They're giving us 5 months in jail. We say, okay, well, you know, that's a good deal. We have a lot of exposure. If we lose at trial, this is a smoke and plea deal, so maybe we take it. And, you know, you might be able to see that work its way out in any criminal case. Now, Ghislaine Maxwell's case, I'm not sure I see that at all, right? She is fighting tooth and nail. Sometimes what we see is all of that clawing, all of that fighting sort of, you know, causes the prosecutor to offer some sort of a deal to say, all right, listen, we want you to serve 25 years. We're only going to ask for 15. Does that sound good? Take it or not. And so if Ghislaine Maxwell had something very, let's say, compelling that she might offer, then she could theoretically do what's called sort of a free talk, right? She's going to give them a bunch of information whereby she is outing, you know, Prince Andrew or whomever, somebody who is big that the government goes, whoa, we'll let you walk if you deliver the goods on all of those other people, right? It would have to be something major, something catastrophic. And I'm not sure that she has anything. I'm not sure what the government would be willing to do in that case, but it is an interesting conversation. You know, there are some situations where plea deals just don't happen, sometimes because it's just too politically volatile, right? Derek Chauvin, there were sort of murmurings that there was a plea deal, but I don't know how serious that ever was. And probably because everybody would have been very mad if he got a plea deal. They wanted their pound of flesh out of him. They want their pound of flesh out of defendants very frequently in high-profile cases, and so they're going to continue to get it. So, all right. So great questions from everybody at watchingthewatchers.locals.com. And a quick reminder that we also have a law firm over here. So I want to share some of these charges with you: drug charges, traffic tickets, felony charges, anything and everything in between. You can give us a call. Phone number 480-787-0394 for the law firm. Point your camera at this QR code and it will take you there. If you want to check out any of my other informational offerings, you can download the Law Enforcement Interaction Training program. Purchase this over at gumroad.com/Robert Gruler. And I would really appreciate a follow over here. So if you want to be up to speed, stay up to speed on some of the info products that I am working on, that is a good place to follow me. Thank you to everybody who asked some great questions today. You see yourself up there on the screen. Very much appreciate that. You keep the community lively and fun, and I appreciate it, over at watchingthewatchers.locals.com. So if you go over there, a lot of other good stuff you can download. Free copy of my book, copy of my slides that we went through today, impeachment party document. You can download that. You can download a copy of my existence system template. We share links and we meet with great people all throughout the day. We have another monthly locals meetup coming up on Saturday, June 26th, which is going to be about 10 days from now. My goodness, coming up soon. So I'm going to post the registration link over at watchingthewatchers.locals.com if you want to join in on that. And so lastly, of course, I am a criminal defense lawyer, as I mentioned previously, here at the R&R Law Group. We've got an awesome team of people here in Scottsdale. We offer free case evaluations. We really love the work that we do, helping good people find safety, clarity, and hope in their cases, and then hopefully their lives. And so if you happen to know anybody who needs help with a DUI, drug offense, anything like that, we would love the opportunity to see if we can lend a hand. Free case evaluations. All of our information is down in the description box below, along with some of the other channels if you want to stay connected, because we do put out a lot of other content. We've got a crypto channel down below if you're interested in blockchain and decentralization. That's really what I'm interested in that for. Less so about, making money or following Dogecoin or whatever. I'm very interested in the decentralized version of governance that we might be able to actually create, that creates a parallel system on top of our current broken system, one that provides more freedom and more autonomy without being burdened by a overly bureaucratic government. So I'm very interested in that. Check some of that stuff out. And I've got an R&R Law Group Arizona channel if you're interested in Arizona law. A lot of good stuff to be connected on. Definitely check out watchingthewatchers.locals.com. And my friends, that is it from me today. I want to thank you so much for being a part of the show. We are going to be back here same time, same place tomorrow, 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. on the East Coast. And for that one Florida man, everybody, have a tremendous evening. Eat a nice, hearty dinner and sleep well. I'll see you right back here tomorrow. Bye-bye.